Good evening, this is John Milburn for Laws 12062 Alternative Dispute Resolution. This is Week 1, Term 2, 2018. We have a number of people online. Thank you very much for joining us. I hope that we will see others in the course joining us on Monday evenings for the live session starting at 7 p.m. Zoom sessions I will conduct Zoom sessions throughout each of the 12 weeks of the unit, apart from the week or so of uni break. Well, it's great to have a number of people on board and good to see some familiar faces. This unit, ADR, is one of my very favourite units, and I do take a few units at the university. One of the reasons that it's a favourite is that it's, for a number of years, been, if you like, my unit. I've taken over from Lance Rundle, who is, I'm sure, very familiar with you, with many of you, and is an excellent unit coordinator. So many years ago, when I inherited this unit from Lance, I had the benefit of some excellent material. So some of the material that you see was prepared originally by Lance and by Professor Stephen Colbrand, who's very well known in this area and, of course, is the head of the law school. By way of background, for those of you that haven't worked with me previously, I am a barrister. I was a solicitor for many years before making the switch a couple of years ago. I take a number of units at this university, and I'm very privileged and honoured to be able to do that. I am an ADR practitioner. I'm nationally accredited. My bread and butter, if you like, in terms of ADR is mediation and conciliation, but we'll talk about some of the other things that we do. For example, in the tribunal where I'm a member, QCAT, one of the tribunals where I'm a member, we have some interesting hybrids, and one of those is hybrid hearings, which are a special type of hearing / mediation process. So that's a bit about my background. I started studying law in 1977, and since that time, pretty much every day I've either studied or decided or taught law. So I do enjoy law and the practice of law. Those of you that have worked in the past with me would be familiar with this quote. I pretty much say it at the start of every unit because I think it's highly relevant, and it's particularly relevant for ADR practice. It goes back to the new lawyer. Remember the text that you probably had in Introduction to Law? I used to take intro quite a lot. At page 267 of the text it says, "Thinking like a lawyer means keeping a cool head, a clear head, and speaking and acting rationally when those around you may be panicking or overreacting." So why do I say that in the context of ADR? Well, in this unit, part of what you need to do is develop a persona, a manner that works to help to resolve issues for people. This is a very practically orientated unit. The first assessment piece is almost pure practical application. It's a unit where you need to demonstrate your ability to both maintain control and engage with individuals who are in a highly stressed state. A stressed state to the point where they may be panicking or overreacting. So what do you do? How do you keep a clear head? How do you behave in a manner that is rational to draw those people in to help them to resolve an issue? Well, part of it's acting. Do we have any actors? Do we have any people that are trained in acting? And I'm quite serious now. This unit, you get to act. It's great fun. And this is what we do in practice. Because we're acting, that doesn't mean we're not genuine. I need to make that point clear. So whilst in a mediation session, if you're ever involved with me as the mediator, you can guarantee that I'll be acting to some degree, but that doesn't mean I'm not genuine, that I'm not genuine about it. So there is, when I say acting, in part, I mean that you are focusing your attention in a very clear manner, and you're being very deliberate about what you do in many instances. At the same time, appearing to be casual and relaxed and off the cuff. I know, it sounds like a conundrum. It sounds a bit odd, but it's true. So when you're acting as a mediator, acting as a conciliator, you will be to some degree acting. Now, Nobody put their hand up to say they've been trained in acting? Anyone? Sharon, did you say yes, you've been trained? No? Okay. All right.
Not in acting, but
Not
it's
in
very,
acting.
no, but it's very similar to what you do in presentation skills as a salesperson.
Yes.
My background was in medical sales, so I'm a nurse. So that was a similar thing where you had to be very well versed, but very natural, but you're still sincere, but you've just got it together.
Yes.
So, yeah.
And sometimes as a mediator, conciliator, arbitrator, not so much arbitrator, but conciliator, mediator, along those lines, Sharon, you are, in a sense, working to an agenda that is somewhat hidden from the participants. I don't mean to make this sound ingenuous or tricky. It's not. But you might have a clear idea of where you want to lead something, and the party, what you're trying to do is bring the parties along with you. And in some ways, it is a sales technique. So I think there are a lot of parallels there, Sharon. Thank you for that contribution. At the same time, and this is really important, you need to be an active listener. I think I mentioned that. To those of you that may have done evidence with me, I would have talked about active listening skills. That ability to hear something and then respond to what had just been said, even though it wasn't part of the script. So even though as a mediator, conciliator, and ADR practitioner, in many ways you want to control the process, you want to ensure that the parties see you as an authority figure without being a rude authority figure or a dogmatic authority figure. They want you to be in control. But just because you're in control, that doesn't mean you completely control the process. In fact, in some ways, quite the opposite. So when you're involved in ADR practice, you will hear things and you need to respond quickly to that and take the opportunity. So active listening skills, very important. Ability to adapt and take up an opportunity and move within a different direction to what you'd initially planned is all part of the job. It's all part of what you need to do. Any questions so far? Have I confused you? Because it will sound a bit odd. And sometimes I'm saying you've got to maintain control, but by the same token, you've got to allow the parties to have the dispute for themselves. Okay, I'll just expand on that. We will talk about this concept quite a bit. As the mediator, conciliator, the ADR practitioner, in whatever form, generally speaking, you control the process, but you don't control the dispute. You don't take the dispute from the parties. Having ownership of a dispute is a valuable commodity. Now that might seem odd. Why would anyone want to have a dispute? Well, what I'm trying to suggest is this. In litigation, the dispute in many ways is effectively taken from the parties. It was their dispute at the start. Lawyers got involved. Then the court got involved. And suddenly the people about whom this dispute relates are sitting at the edge of the bar table, mute, not party to the discussions, and the dispute is taken from them. The lawyers and the court or the tribunal take over. The decision is then imposed on the parties. ADR represents an opportunity for you to be part of a process which is in many ways diametrically opposed to that process of litigation, in the sense that you are allowing the parties to maintain ownership of their own dispute. You set the groundwork, you provide the base, you control the process, but at the same time you let the parties keep ownership of that dispute. That'll make more sense as we progress. So these are some of the differences between ADR practice and litigation practice. Okay, let's talk about the assessments for a bit. Let's just digress. Because those of you that have worked with me in the past also know that one of the things that I'm very keen for you to do is to work backwards, to look at how to prepare now for what you want to achieve at the end of the year. So, first thing that we want to do is look at the way we discuss and issues during this unit. And this unit, we're going to be using uCrew. So if the share screen is working correctly, you should see the uCrew. If you don't, please let me know. So that's the alternative dispute resolution page. If you're enrolled early, relatively early, you've already been enrolled in uCrew, so you can just click the link on Moodle and come to this page. So you can see some activity. Faith, thank you very much. Sharon, thank you. B, thank you. Lisa, thank you as well. So there's been some activity already, and you'll see that each one of those posts have been initiated by students. And that's a big part of uCrew. It's your opportunity to ask a question, to make a comment, to share some information, to provide some detail about something that you found, a paper, a video, or some other resource that you want to share. And whilst you've still got the opportunity, I haven't yet removed material from last year. So you can go in and have a little sticky beak at some of the discussions from last year's cohort in alternative dispute resolution. But it's only for a limited time. It won't be there for that long. So that is the way in which we discuss the unit. We go through uCrew. I have disabled the Q&A section, and you won't be able to see it through that. Craig asks a good question. How long do we have before I remove it? Well, I'm not sure how long I will leave it there. And if you haven't got access yet, don't worry. I took action today to seek to enrol more people. So maybe as early tomorrow or the next day, if you're unsuccessful in the link, you might be enrolled now. It's a bit of a rollout process. All right, so the next thing is Moodle. You're all familiar with Moodle. I won't dwell on it too much, but I'll just show you a few things that I want you to consider in the Moodle site. You should see Moodle, the Moodle page for ADR. So just a few comments about welcome. You'll see below the learning outcomes the link to tonight's lecture. Thank you. I'm sure you've all found that link because you're here tonight. The uCrew class discussion and the news forum. I will post information in the news forum, and Nicholas has done that as well. So thank you very much. So that's another way in which we can communicate. Please ensure that you consider the plagiarism and academic misconduct page. That is new. It's something that you should find on all of your units now. It's a new requirement for standardization of procedure in Moodle. You'll also see useful tips and learning support is a new page which should be common to all of your units. We now move down to assessment pieces, and you'll see the two assessment pieces. The first is the audio-visual presentation, 40% of the overall assessment. It requires you to complete a Word document, but only a basic, simple Word document. There's no marks allocated for the Word document as such, but the real assessment is the audio-visual assessment. And the second assessment is the briefing paper, as we describe it, or the take-home paper. And I'll release that on Wednesday, the 3rd of October at about 6:30 p.m. It's due the next day by 11:45 p.m. So you won't be able to see that paper until I release it on the 3rd of October. It's only 2,000 words. It's 60% of the overall assessment, and there is no opportunity to extend that time. So whilst you have the opportunity of submitting your work late in terms of the first assessment, with suffering a penalty deduction, in terms of the second assessment, if you don't submit by the time you get nil marks, which means that you will effectively fail the subject. and we don't want that. Okay, so what do we need for passing this course? Again, I'm making these comments in the spirit of looking at what we want to achieve and then working backwards from that. The take-home paper, well, it's pretty easy. I guess the first thing you need to do is make sure that you're free on that day and try to minimize any other distractions. So if you have an opportunity to take time off work or to arrange for childcare or any of those sorts of things, please do that now. I appreciate that week is likely to be a big week if you're studying a number of units, because there's a good chance there'll be other units where there is assessment during that week. If there is a clash, I'm sorry, but it's very difficult to change those dates. So hopefully you can work towards that now in terms of being available and ready to go. Let's look at the first assessment. The first assessment is the audio-visual. It's due on the 6th of September, which is week 8. Oh, that's miles away. We've got plenty of time. You can submit early, you can submit tomorrow if you want to. But what does the assessment mean? Well, firstly, you need to organise a group of 3. This is not a group assessment. You're not being assessed as a group. The idea of suggesting through 3 group members is that you can then work on having your individual assessments filmed and uploaded, where for one of the 3, you are the mediator or the conciliator, and in the other 2, you are a participant. You're one of the parties in dispute with the others. So it's a rotating chair situation. Does that make sense? So if you have 2 mates from the unit where you work with, you can compare notes, you can discuss the topic, you can give each other ideas, you can collaborate in that sense, as you can with other members of your unit as well. And then you can decide, okay, we're going to film this audio visual, and I'll be the mediator or the conciliator for the first one. The other 2 are in dispute, and then take over from there. You don't have to do this on the same day. You can do this on separate days. Sharon, did you have a question?
Yes. What do you do if you're a distance student in Auckland?
Okay, well, the good thing is that we're all distance. So there's nobody on campus. So being in Auckland is just the same as being in Rockhampton, insofar as this assessment is concerned.
So how do we film each other? Like, we won't be in the same room, will we?
No.
Okay.
You can be. I mean, some people do that and they set up, a tripod with a camera. Personally, I think it works best if you film it via Zoom, as we're doing right now.
Yep.
So most of the assessment pieces that I come in for marking, I see 3 people on a screen just like this, and one says, I'm the mediator, welcome to the mediation. We're doing this mediation by audio visual, but to some degree you can mock it up as if it's a face-to-face mediation.
So it's live, we don't record it?
You record it in one session.
In one session?
Yes.
And then you view it?
And then I view it.
Okay.
Yep. So what you do is you learn the technology first up, and in the assessment piece and on Moodle, I've actually provided you with some fairly clear guidance as to get around the technology. It's pretty simple. Once you're enrolled in Zoom, you can record it from your end. So you just set up a Zoom meeting, you hit the record button, then you need to upload it in a form that I can see it. That probably means uploading it through YouTube. Those of you with a channel, with experience, will find that dead easy to do. If not, it might be a new skill for you to learn. You need to set it such that I can view it. That may mean going public with it. I'm not sure that's necessarily, I'm not sure that's not a bad thing. I think that's a good thing. Many of you that worked with me in Introduction to Law would have developed a portfolio. Did anyone work with me in Intro or others? Diane did.
Yes, me too.
Yeah, Sharon did. Yep, Jackie. And it wasn't just me. I think Wayne Jones and Scott Beattie were doing the portfolio as well. in Introduction to Law. So if you record your session, with the permission of the 2 students that you work with, you could upload that as a link to showcase your mediation or conciliation skills. Monique says, unlisted video means you can share the link and only those with the link can view it. Okay, thank you, Monique. So feel free to do that, but just make sure that you test it and so that I can see it, because when I'm doing lots of these, I do like to be able to open it and see it so that it works. Monique, I'm sure you'd be happy to help people if they're struggling. Would that be the case?
John, it's Nicholas. Remember, I created those video series.
You did.
It's the one that shows people how to do all of that, and it's still available. My link is still there.
Thank you, Nicholas. Absolutely, you did. I wonder if I have copied that across to this course, to this unit. Oh, but yeah, no, for those of you who haven't worked with Nicholas before, he was an absolute whiz at this. So thank you very much.
Yeah, you asked me if you could share it that semester, John, and I said yes. I gave you the permission to do it. So anytime, if you don't have it, send me an email and I'll send you the link through.
Great, and I'll have a look. I certainly did use it for later offerings of Introduction to Law. So thank you, Nicholas. Appreciate that. Okay, so what does that mean? It means now you need to learn the technology. You need to read that first assessment. It's week 8, but just ignore the week 8. You need to find 2 other members of the group, the unit, to work with. And once you've identified 3 members, send me an email if you would, and make sure that you copy your fellow students in on the email so that I can hit the reply button knowing that it's going to all 3 of you. I will update a document which I keep and then put on Moodle saying, here are the group members. You can have 4 in the group. That works just as fine. That works fine. If you have 2, you can bring in someone who's not part of the unit, or you can ask someone who's already in a group if they wouldn't mind doubling up. So quite often students are happy to do that. They say, yeah, I'll be a participant in your dispute, showcase my acting skills. If you're really struggling to find anyone within the group, you can bring in outsiders. Now, you're probably thinking, what dispute are we going to deal with? Well, here's where you get to choose. And this might reflect your particular interest. So if you have a real interest in, say, environmental law, your mediation or conciliation might be based around a dispute between a protester or an objector to a proposed development and the developer, who are at loggerheads in terms of the conditions. That's just an example. Or if you have an interest in family law, it might be between disputing parents in relation to property or child. It might be a neighbourhood dispute. It might be a dispute between co-directors of a commercial operation. It might be a dispute between a franchisee, a franchisor. It might be a farm debt dispute between a bank and a farmer. A whole range of things that it could be. I get to see some really interesting dispute scenarios. So your role in this assessment initially is to find the people that you're going to work with, then develop a dispute scenario. 2 ways you can do this. The first is you can fully script it. If you like, I don't mind, you can write out a 5-page document, which effectively is the script, like a play, and people will read their parts. I'll bet you don't do that though. And I'll say that for a couple of reasons. The first is, unless you're really good at acting, I'm going to tell that that you're reading it. And so the marks, the discretionary marks that I have for the way in which you operate as a mediator or conciliator is likely to suffer. What you'll probably do is try and keep it reasonably fresh, and you'll probably try to genuinely be on your toes and, to quote Judge Kingham, light on your feet as an ADR practitioner by having some surprises built into it. Now, some of your surprises might be that people introduce new things that you didn't expect. They might purport to walk out, and you've got to try to draw them back in, just like Al Pacino's character in Godfather Part 2. You know, whatever it is that happens, it might be best to keep it a little bit fresh. So work out what type of dispute you want. Do that this week. Have that buttoned down. And then start to think about some of the things by way of the facts. Present the factual scenario to your fellow students and say, look, here's the basics of the dispute, and just work from there. Does that make sense? Any questions on that? All right, good. So how do you find your groups? Yes, sorry.
I just have, sorry, I'm going to put my volume up. I just have a quick question about the shuttle. I've done a little bit of the reading, and in the assessment piece it suggests that incorporating private sessions or, you know, shuttle mediation. How do you suggest, if you have a suggestion, that we get around that with the Zoom setup?
Okay,
Thanks.
That's a really good question. Well, firstly, I have a preference against shuttle mediations. I'll just disclose that. Some people have shuttle mediations from the outset. I really don't like that. There's nothing. Many practitioners, many ADR practitioners, work almost exclusively in shuttle mediations. I just don't like them. I think it goes against my grain. So I would suggest to you that you don't do a shuttle mediation from the outset. But that's very different to having private sessions. So to answer your question, Monique, we'll talk more about what's involved in a mediation process. But in a mediation, you normally have an opening, then the parties have an opening after you, as the mediator or conciliator, has given an opening. And then you have an open discussion. You have this sort of joint session where all three of you are involved in the discussion. And at some stage during your mediation, I'm going to encourage you to go into joint sessions. So from a practical perspective, that might be you as the mediator or conciliator saying something to the effect, it might be useful now if you break into joint sessions. You would have explained what a joint session is at the start, and indicate to one of the participants if they could perhaps turn off their volume or maybe leave the room. It's up to you how you actually do that, but I don't mind if you have one of the participants just blacked out so they can't hear you, but they can maybe see you, and then you can just wave them in, like physically just say, okay, come on in. And you probably have some idea that the joint session or the private session would take only, 5 minutes or so. Okay, thank you, Monique. Now, I think I saw a really interesting comment from Jackie. Did you want to elaborate on that, Jackie?
Okay, so I'm a conciliator with the Fair Work Commission. So we generally do joint sessions to start with. However, if there are criminal charges likely or currently pending, if it's likely that the applicant might incriminate themselves, we might just do shuttle negotiations, because obviously I could be called to give evidence against them, and I certainly don't want to have to do that. So we might just do shuttle negotiations where we don't actually talk about the potential criminal charges. Or also, given the idea with unfair dismissals, parties can be really upset and angry, and they might decide that they want to participate, but they don't want to do joint sessions. And I would do shuttles at that point as well.
Yes, so they're very good reasons. Another good reason to do shuttle is in domestic violence situations. But quite often I will start as a joint session, even though it may, as Jackie mentioned, develop into a shuttle, or it can go the other way. If the parties are adamant that they're not prepared to meet in a joint session, I might start in a shuttle situation, but in the end, I always like to try to bring them back into a joint session, particularly if we have a resolution. So thank you for that contribution. Diane said, does the scenario have to be the same for each person in the group? And the answer is no. So the idea is that your scenario is yours. So within the group of 3, you might have a family law dispute, a commercial dispute, and a criminal law dispute, whatever it might be. So they don't have to be the same. All right. Speaking of criminal law disputes, that's an interesting area, and I think very much underused in the context of ADR. So an interesting mediation session for me is where I'm asked to mediate where someone has been charged with typically a property offence, usually a serious property offence, and with the concurrence of the prosecution, I mediate with the alleged victim and the alleged perpetrator to attempt to resolve the matter. All right, so that's another option for you to consider. So you know now what this first assessment is about in general terms. You know that you prepare a short Word document. You embed a link to your video. In that Word document, you upload it to Moodle. I will then download it so that I can see your Word document, click on the link, get straight through to your video, and then I'll mark your video assessment. I will provide full feedback in relation to that exercise. With the take-home paper, I won't provide any individual feedback, but I will provide general comments for the class. I hope that I have provided past assessments for you. If not, I'll do that. Yeah, I've got the take-home papers from 2015, 2016, 2017. This unit's only offered once a year, so they're the last 3 that I've done. Have a look at that. You'll see that there's quite a variety of different approaches to the take-home papers. So I won't give you any hints at this stage as to what will be this year, but I may give you some hints as we progress. One thing you probably picked up on is that I'm very keen on collaboration. Now, this is not collusion, but collaboration in a positive sense. And what better one to have collaboration than ADR? So please feel free to share ideas. I would be very grateful if you did, and help each other through this unit. All right, we'll keep moving. Textbooks. That's the prescribed text. It's pretty easy reading. It's only a short text, but it's very good. So that's by David Spencer. The supplementary text is excellent as well by Tanya Sorden, and that's a bit thicker. Alternative Dispute Resolution, that's the 5th edition. There are some other really good textbooks. I might mention these for you briefly, but David Spencer has a cases materials supplement. That's much more significant, but I haven't prescribed these things because they can be quite expensive. There's one called Mediation Skills and Techniques by Boulay and Alexander. That's very good for the first assessment. Mediation Principles, Process and Practice by Boulay, also very good. And Negotiation by Alexander, Howison and Fox. There's plenty of other good textbooks around, but they're good ones to consider if you're looking for a bit of extra reading. Right, any questions so far? Comments? Nothing? All good? I think you all know how to present your work with me. There's a sample document. Have a look at that on Moodle. Okay, so ADR. Let's get down to some content. ADR is relatively new. It's a little bit like e-law and environmental law. It's a relatively new discipline in a way. It's new in this sense that there was an American litigator who came up with an idea of trying to resolve the issue in a shorthand manner. This was Eric Green. He proposed settling a large litigation matter by putting 2 days aside, having some ground rules set for the parties to litigate the dispute, and away they went. And it's taken off. That was in the 1980s. I was studying when a friend of mine went to America to study psychology, came back and said, I think you need to get into ADR. Mediation is going to be a big thing. I mean, at the time, people thought mediation was meditation. I mean, we didn't know much about mediation in the 80s. And so I looked into it. And so I was I was early on in my training for mediation in the 80s. So it's developed in leaps and bounds since then. Lisa, did you have a question?
No, sorry, I just came back online.
Oh, okay, no worries. Thank you. And if anyone does have a question, please let us know. But mediation and conciliation have actually been around for a long time. So if you look at the Constitution, Section 51, subsection 35 talks about powers in relation to conciliation. So it's new in the modern sense, but the concept has been around for a while. In fact, let me read this quote or this material from Tanya Sorden's preface to her book. I'll try to be quick on this, but it says, so this is from this textbook, Alternative Dispute Resolution. Our world continues to present us with many opportunities to consider options for peaceful and effective conflict resolution. These opportunities arise at the individual, international, and organisational level and represent a paradigm shift. Within Australia, the new paradigm has an impact on the legal system, has the potential to transform the role of lawyers. The tension that exists as lawyers act as advocates, peacemakers, and negotiators has been present for many years. For example, Abraham Lincoln once stated, "Discourage litigation, persuade your neighbours to compromise where you can, point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. That will be business enough." So it's been around for a long time. Whenever I read something about Abraham Lincoln, I always think about Bill and Ted. Those of you of a certain age will know Bill and Ted. Otherwise, you have a parent who was interested in Bill and Ted. And by the way people are looking at me, you have no idea who I'm talking about. You'll have to Google that one. Anyway, let's move on. So it's been around for quite a while, but by the same token, it's new in its modern context. Tanya Sorden also makes another interesting observation. She says that for lawyers, this shift and this consideration about dispute resolution processes that are now incorporated into the system has profound implications. And there's a quote, and this is true: "Only after graduation do your attorneys come to you to the depressing realization that 90% of what they were taught in academia will never be used in practice, and conversely, 90% of what they need to know in practice was never taught to them at school." I went to the University of Queensland. I was really pleased that I went there. It was a great university, still is, but at least in my day, I would have been lucky to use 10% of what I've learned, and I would have been lucky to know 90%, in practice. So it's a little different now, but this unit is very practical in its application, and I want you to approach it in that way. How would I actually use this? See, one of the things that you might do this week, this is not on Moodle. This isn't one of the things that I want you to actually write about necessarily, but think of it this way. In your reading, I want you to consider issues to do with negotiation and some of the formal processes. So start using some of your skills around the house. Don't necessarily tell people you're using them. So on the weekend, if you're catching up with family or whatever, use your active listening skills. Think about your body language, because that's all part of it. See if you can engage with them in a certain sense, but have a little ulterior motive going to see if you can do something. Now, I know this all sounds very tricky and it's acting, but it's all part of ADR skills. So just do a little bit of practice in terms of how you use the skills that you're talking about. Negotiation skills, for example. Anyway, that's all very vague, but I just want you to keep what you read in mind in a practical sense. All right, so ADR is something that you will use in the court system and outside the court system, because ADR practice is now embedded in the process. So apart from the textbooks, you will need to know the provisions about ADR in, say, the UCPR. Sorry, have we all studied civil practice? Has anyone no one's studied civil? All right, do we know what I mean by the UCPR? Yes? Who wants to volunteer? What's the UCPR?
Universal Civil Procedures Act.
Close. Close. Uniform Civil Procedure Act. So, Uniform Civil Procedure Rules. Yep. UCPR. So thank you, Amanda. I think Diane was diving in there as well. So Uniform Civil Procedure Rules, as they're known in Queensland, you'll need to have access to that. It's readily available on the internet, and there's some good commentaries, I think, in the CQU Law Library as well that provide some information about that. So it's all part of the mainstream process now. When we're talking about ADR, we're talking about a wide range of different techniques. It's not just litigation. We're talking about everything other than litigation. In fact, I mean, it's so new, this area, that in some ways people have not yet really settled on the name of ADR. You know, there was a dispute. There was a little bit of a dispute at the start what we should call this. We called it alternative dispute resolution, but you know, there was a push for it to be called appropriate dispute resolution. Still ADR, but just a different word. And some people still say that that's what we should call it rather than alternative dispute resolution. So it's all kind of new, but you'll read about that in the material as we progress. And you'll read about the tensions between those that believe we should focus on pure litigation, which tend to be perhaps the more senior barristers in some situations, or senior judges, as opposed to this new, approach of mediation and conciliation. But now it's all intertwined.
On that point, John,
yes, Nicholas?
in this week's reading, I noticed in section 3.2 where it talks about what is alternative dispute resolution. There's a section there that says, whilst litigators may see the word alternative as being the correct term, and then straight away after that, it says litigators and non-litigators see the word as being inappropriate. So which is it? Do litigators see the word as being correct, or do they see it as being as inappropriate and inaccurate?
I think litigators see it as being correct because it's alternative to litigation. And for litigators, litigation means everything. So anything else is alternative to that. So, but look, I think we could probably stick with alternative dispute resolution. It's pretty widely used now, but it wasn't always that way.
Yeah, no, it's just a conundrum in the way that phrase is worded in that paragraph. It just seems to go round in circles and back on itself.
Yep, no, that's true. I can appreciate that. What I might do, and I don't think I've uploaded this, I'm going to upload an article by Robert McDougall, which talks about the courts and ADR and the relationship between the two. And that would be interesting reading, Nicholas, because the author does talk about the history and talks about how it's used in practice now. So I'll make a note to myself to upload that. So I've got a few things here that I must do. What I want you to do is have a look at something in the textbook and be prepared to refer back to it at regular intervals. Now it's on page 3 of the text. It's figure 1.1. So it's not far into your reading, and I'll just do a close-up. You see that sliding scale? Okay, that's useful because that identifies in that figure 14 different types of ADR. Now, we might think ADR means mediation. Well, mediation is one of the 14. We might think, oh, well, it's either mediation or conciliation. That's 2 of the 14. Can anyone think of another one? You've got a chance to do some typing now, or just unmute and let me know. And you're all going to look at the textbook now, aren't you? What are
No,
some of the
I
others?
did the reading today, John, and facilitation was the other one because you asked us
Yes.
to put it in our little diary each week.
Oh, okay. Very good. Facilitation, arbitration, negotiation. Thank you, Monique. Any others? They're all good answers. Collaborative law is an interesting one. Collaborative law, you'll read about that in the context of, does anyone know? Collaborative law. What do you think of? What type of dispute do you think of when you're thinking of collaborative law? Or at least I do. Family law. So if you're thinking about a family law career in family law, I would definitely pay good attention to collaborative law. And then you get the building ones. When I look at dispute review boards and dispute advisors, and even partnering, I'm thinking building disputes primarily. Anyway, a whole range of things. Have a look at that chart because it will help guide you through and give you an idea of which are the most informal and which are the most formal types of processes. Mediation and conciliation, kind of somewhere in the middle there. All right. What else did I want to talk to you about tonight? I think we've covered most of what I wanted to talk about. Is there anything that we need to discuss? Do you have any questions? So you've got an idea that in ADR, it's very broad. It deals with disputes that cover almost every part of the law studies that you're studying. Tonight, we've talked about disputes in a whole range of areas, including criminal law and environmental law. They all work. Okay, if you have any questions, please think UCrew primarily. If you have any contributions, think UCrew. Nicholas might even upload his videos and I'll try and find them as well. Thank you, Nicholas, for your offer again. I've mentioned that I'll upload an article by McDougall and I'll put that into the week 1 materials. Don't forget, we have the additional resources as well. And if I could just mention that I created a video, I think last year, which I'm not sure if I put it in there, but it talks about, yes, level 3 examination and online paper presentation. If you haven't watched that video presentation, I would recommend you do so. It's at the bottom of the assessment and reference information, which is under the assessments tab. And that gives you an idea of what I expect you should be doing as you prepare towards the end of the unit for your take-home paper. All right, all good? Okay, great to see you all tonight. I'll wrap it up unless there's any questions or comments.
Thank you very much.
All right, very good. We'll see you next week. Okay, all the best. Bye then.
Bye.